before I give my views and before I answer this question, I would like to quickly run through this judgment, the salient features of this judgment. First of all, this judgment categorizes prisoners into different categories. Category A, B, C, D. Offences punishable with imprisonment of 7 years or less, with death, imprisonment for life, or imprisonment for more than 7 years, category 2. C, offences punishable under special acts, NDPS, PMLA, etc. And D, economic offences not covered in the previous category. So it categorizes prisoners in these 4 categories. Then the judgment goes on to observe that the prevailing situation in India is precarious. We have India is flooded with under trial prisoners. 2/3 of the inmates of the prisons are under trial prisoners. Of this category, majority may not even need to have been arrested. Why were they arrested in the first place? The Supreme Court observes that. And most of these under trial prisoners are from poor backgrounds. They include women also. And the Supreme Court goes on to say that this situation in India exhibits a mindset that is a vestige of colonial India. We are still very colonial. Our police force is still very colonial. And that has been said time and again, including in Arnesh Kumar, that the police refuses to give up the colonial attitude, the colonial prerogative of arresting the accused. They don't want to give it up. Another feature the Supreme Court reiterates in this judgment is bail is the rule and jail is an exception. Well settled principle of law. Another feature highlighted in this judgment is that the Supreme Court has recognized that Arnesh Kumar is not being followed in letter and spirit in the criminal justice system. Arnesh Kumar was decided in 2016 and now we are in 2022. Still you find arbitrary arrests every day when you open the newspaper. Every day as criminal lawyers we come across cases where you ask yourself this question: why was this accused arrested in the first place? So the Supreme Court says that in spite of guidelines, in spite of reiteration of Arnesh Kumar again and again, it is not being followed. Then the Supreme Court goes on to say that a mandamus is given to the courts to take severe action against police officers who do not follow Arnesh Kumar. Normally what happens, once a man is arrested, the legality of the arrest loses significance and the whole focus shifts on bail applications. Legality of the arrest is not gone into by the criminal courts and the whole focus is on bail. So the Supreme Court says that Arnesh Kumar, for violation of Arnesh Kumar, severe action should be taken against police officers. Now I can see the beginnings of arrest justice, if I may coin this expression. Justice Waziri recently in 2022 sent one police officer to jail, maybe for a day. So you can see the beginnings of arrest justice in India, and I hope after this judgment more action, deterrent action will be taken against police officers who violate Arnesh Kumar. Another principle, another important feature of this judgment is the Supreme Court says that where investigation must be concluded expeditiously, and if it is not concluded expeditiously, bail should be granted on this ground. This should be one of the important factors, important parameters for the grant of bail. Then the court goes on to say that expeditious trial flows out of Article 21. And if the trial is not expedited, it should be a factor in the grant of bail. The other day I was arguing, I'm still arguing this matter, where the man is accused for 302, in jail for about 12 years. And only about 44 out of 78 witnesses have been examined. Why should he be not granted bail? Now I can see bail justice evolving in the Supreme Court. Now you have some orders and judgments where the Supreme Court is following broadly a 10-year rule. Or for example in Indrani Mukherjee, the Supreme Court, without going into the merits, without going into the seriousness of the allegations, has said, since the lady is in jail for 6.5 years, the trial will not be concluded in the near future. Therefore, bail has been granted. So you have these orders, you have these judgments which are coming in from the Supreme Court. It will take its own time for these judgments to percolate into the criminal justice system. Because there is a certain mindset. We still follow the labeling theory. Once the label of 302 for a serious offence is put, so then the judges normally say no bail in such a case, hands-off approach. So I hope that will also change after this judgment. Another important feature is section 436A should be effectively in play. That where long incarceration, where a person has undergone imprisonment of more than half of the maximum sentence, etc., should be granted bail liberally. Then the Supreme Court goes on to say that in category A cases, that is where offences are punishable up to 7 years, the bail discretion should be exercised more liberally insofar as such offences are concerned. Insofar as category C is concerned, the Special Act, PMLA, NDPS Act, the Supreme Court says 436A should apply to such cases and expedite the trial. I have come across cases where 10 years trial is going on and on indefinitely in NDPS matters. No bail is granted. In fact, NDPS courts are known for non-grant of bail. If you go to Punjab Haryana High Court, you will know, how bail is liberally granted in these NDPS matters also. Because there are false implications, there are misapplication of law also. So there are some of the accused may get implicated, for being in a certain place with some people at the wrong time. Because 34 and 120B are extremely colonial in nature, and you can implicate anybody and everybody using these 120B and 34. Then very interestingly, very important, the court ultimately says, what is the role of the court in matters of bail? The court says the rate of conviction in criminal cases in India is abysmally low. It appears to us that this factor weighs on the mind of the court while deciding the bail application in a negative sense. Courts tend to think the possibility of a conviction being nearer to rarity. Bail application will have to be decided strictly, contrary to legal principles. This is a very typical mindset. Courts know that is 302 when nothing will happen. Ultimately, acquittal will happen. So keep him in jail for 10-15 years. Because the credibility of witnesses and so many factors are in play. So this Supreme Court has observed, and then Supreme Court says we cannot mix up consideration of a bail application which is not punitive in nature with that of a possible adjudication by way of trial. On the contrary, an ultimate acquittal with continued custody would be a case of grave injustice. Finally, we are waking up to this scenario. What happens when you acquit the man after 10 years or 12 years and he has suffered that incarceration, and the acquittal is not on benefit of doubt? It is an honorable acquittal where the investigation was found to be shoddy, where it is found to be a case of false implication, etc., or a case of no evidence, etc. What happens? So finally we are waking up to this scenario that injury is irreparable. You can't repair it with money or anything. And what is the cascading effect on the family of the accused, etc. Finally, the Supreme Court says, and then the Supreme Court says that when the trial judge or when the court hearing a bail application, he should be like a high priest. That the word used is high priest. In fact, the principle of beyond reasonable doubt has come from these priests. At some point of time, the priests would be a part of the jury deciding criminal matters. So then, the thought was that it will be a great sin if I convict an innocent. So therefore, this principle of beyond reasonable doubt, the Blackstonian principle, that 10 criminals may go scot-free, one innocent should not be incarcerated. So that's the Supreme Court says that this is, the bail application is like deciding by a high priest. That's how you decide bail application. Finally, the Supreme Court says that we need a separate bail act in India. And the direction has been given to the government of India to consider making a special law with respect to bail. Like in the US, like in some states in US and in UK, you have a special bail act. Now the question is, should we have a separate law? That question, I will address this question. In my view, bail justice in India is very complex business. It's a very complex area of law, especially in the Indian context. Why? You follow a liberal approach, you may have many criminals roaming scot-free on the streets. You follow a very conservative approach, you may have a lot of innocents, lot of accused who are eventually found to be innocent, incarcerated for years together in jail. So therefore, and then different types of cases call for different treatments at different times. Now this is one statement. You can't bundle cases, you can't classify cases 7 years and you can't classify. It's too broad a classification in my view. I'll give you examples at different times. For example, bail in 376 was a complete no in the past. Then, the economic offences post 1991 have grown. So there is a zero tolerance towards economic offences. That they are worse than murders, etc., etc. Yes, yes. So therefore, at different times, the needs of justice also change. Now, with the increase in false cases of rape, courts are open to granting interim, stay or even anticipatory bail. Another example, 498A was blunted by Arnesh Kumar. Now you have 377 added to that to make it more serious. To come out of Arnesh Kumar, an anticipatory bail is being granted. So if you categorize and fossilize offences in different categories, it may not stand the test of time. Different times need different principles of justice, bail justice, to come into play. Now, with increasing misuse of law, for example, in commercial offences, you see these offences, and my good friend will bear testimony to this. Typical FIR, you will have 406, 420, 463, 467, 468, forgery, everything under the sun in an FIR. Whereas there is no forgery, 409 to make a life imprisonment. And eventually when you read the file, it's a core civil dispute wearing the clothes of a criminal complaint. So once you categorize cases, it may not work in my view. So therefore, bail justice should be left to the discretion of the courts. Courts know where to draw the Lakshman Rekha. Courts are not blindly granting bail to anybody and everybody. In fact, even in PMLA matters, in my view, it should be left to the wisdom of the courts. Courts don't grant bail mechanically to everybody, to every accused. Rather than putting this in a statute book, that say 7 years, bail in so much time, etc., etc. Now, there are myriad species of cases. And within the species of cases, there are so many types of cases within the species. For example, in a case of murder, exhortation. Now we all know, time and again, the Supreme Court has said that exhortation is a weak allegation to falsely implicate all those people, who are known to the main accused. In a typical rural sector, you will call these cases in Punjab, they call them lalkara cases. उसने ललकारा दिया, उसने कहा मारो उसको, उसने पैर पकड़ा, उसने बोला इसको खत्म कर दो इसको आप. So read with 34, all are made accused. Now if you were to apply some strict principle of bail, what happens to them? So there are so many species within every case. Then the Supreme Court has said time and again that every witness in India commits perjury. Every testimony is full of exaggerations, embellishments, falsities. Grain of untruth is there. That's why we have the principle of chaff and grain being separated. How can you classify offences? So it is best left to the wisdom of the court. The Supreme Court time and again has lamented at false implication during investigation, shoddy investigation, padding, they call it, the prosecutors call it padding. This case ko pad karo. Recoveries are planted frequently. False witnesses are created. So with all these problems, you cannot, in my view, categorize and classify offences and then make some formula with respect to bail. Hence, in my view, in view of all these factors, it would be best to leave bail justice to honourable justice. Thank you.
Thank you very much, sir. Now, I would like to have a question answer session with Mr. Vivek.
Let my colleague here. Then we can have it at the end.
Now, I would like to call our second distinguished speaker, Shri Vikas Pahwa ji. Sir primarily deals in criminal law litigation. In January 2008, Sir was appointed as Additional Standing Counsel Criminal in Delhi High Court to represent Delhi Police. In January 2009, Sir was also appointed as Standing Counsel for CBI in the Delhi High Court. Sir successfully prosecuted Maruti Suzuki Indian Limited Manesar factory riot case in which the general manager HR of the company was burnt alive and 90 employees of Maruti Suzuki were severely injured. Mr. Pahwa appeared Maruti Suzuki India Limited before the trial court. This mammoth trial took 4.5 years to be concluded, in which 148 accused persons were prosecuted. The trial convicted 31 accused persons in March 2017. Appeals are being hearing in appellate court in Punjab and Haryana. Sir is also empanelled by the Delhi State Legal Authority as senior counsel for appearing in legal aid cases in the Delhi High Court. Empanelled by the National Legal Authority as the senior counsel for appearing legal aid cases in the Supreme Court of India. Empanelled by the Supreme Court of India as amicus curiae in the special cases pending in the Supreme Court of India. Sir did an advanced course on international criminal law in the Hague Academy of International Law at The Hague in November 2018. We welcome you, sir. Sir, kindly enlighten us on the topic.
Good evening, everyone. Thank you, Sood, for giving us the opportunity. And my friend is also here, Mr. Podal, and all my young colleagues at the bar. I think we all know each other well because we practice in the same court. So I don't think this introduction was required. But anyway, I think it's a formality. My friend has said some good things about me. Yes. So I've heard Mr. Sood who spoke about the judgment. I think that judgment is the turning point. But the problem today, I mean, what we see in the court every day. So I would like to address the issue. And this issue, whether we need a statute or not, is not a new development. And for the first time, the problem of bail was highlighted by Justice Krishna here. You know, when I was very, very young, I'm a third generation criminal lawyer. So I heard about bail when I was in my school. And my father used to talk about some bails are granted, some are not granted. So I used to be very, it was very inquisitive for me to know what is bail. So when I was in 8th or 9th, I was told that bail is like a certificate for someone to come out of jail and roam free. And when I started practicing, I joined my father, who was a great criminal lawyer in UP. He was called King of Bails. So when I joined him, so few of my colleagues, in the office, used to refer him that he's the King of Bail in Meerut. And so I used to, inquire from them, why is he called King of Bails? So they said because he does 50% of bail application in the district. So if there were 25 bails which were supposed to be argued, 50% were argued by him, and he had a close to 100% result. So he was called King of Bails. So I got inquisitive, then I started practicing on the criminal side. I was basically doing my chartered accountancy. So this King of Bail and bails and arguments and variety of criminal law work which I saw in Meerut at that point of time really attracted me to this practice. And when I shifted to Delhi, I realized that bail in that part of state is much more liberal, and the orders which are passed by the courts in UP and various other states like even Bihar and Odisha, the judges are more liberal. And Punjab, of course, as mentioned by Vivek also, in NDPS cases, Punjab is very liberal. So when I came to Delhi, I realized that bails in the capital are very, very tough, because in early 90s, when these non-banking financial companies came and all these people were arrested, a prejudice was created in the mind of the judge with regard to financial crime. Now most of our cases in Delhi are financial crimes. So bails are not very easy here in Delhi, and now with some more new judgments, it is becoming more and more difficult. Now what is the problem? The problem is highlighted by Justice Krishna here in 1978, and I would like to read one paragraph, and I think that probably closes the issue, and that issue till date is not resolved. What are those 4 or 5 lines that Justice Krishna here said in that judgment? This is Buddhi Kanti, 1978, where he said bail or jail. So he very beautifully presented in that judgment the issue, the problem. And the problem is, he said the subject of bail at a pre-trial or post-conviction stage belongs to the blurred area of the criminal justice system and largely hinges on the hunch of the bench, which is called judicial discretion. As Vivek also made a mention that we should leave it to the wisdom of the court. The wisdom of the court is the judicial discretion. And according to Justice Krishna here, 44 years back, that's the blurred area of criminal justice system. Because every judge has his own understanding of law, has his own experiences in life which have an impact on the outcome of the case. And he further said, the code is scripted, code here means CRPC, the code is scripted on this topic, and the court prefers to be tacit, be order custodial or not, and yet the issue is one of liberty, justice, public safety, and burden of the public treasury, all of which insists that a developed jurisprudence of bail is integral to a socially sensitized judicial process. So in 1978, he highlighted that this is an issue which requires judicial discretion. Discretion may be in favor of an accused, may be against. So therefore, we need to do something. Post 1978, we have on anticipatory bail, we have various judgments. We have Gurbaksh Singh CBA, and we have Mahatre's judgment, and then finally we have Sushila Agarwal, which is a constitutional bench judgment. There are 3 judgments on anticipatory bail. And similarly, on regular bails also we have various judgments. We have Sanjay Chandra, we have this Antil judgment. So if we see right from 1978 till date, we have various judgments written by Supreme Court where the law on bail has been clarified. Time and again the Supreme Court says that we have to be liberal in bail. Why we have to be liberal in bail? Because of the situation of our country. Today we have 75% of prisoners in jail who are under trial, which reflects on the criminal justice system. And in fact, Prime Minister Modi recently in Vigyan Bhavan also said that please do something. These under trial prisoners, most of them are from a poor state of society. They don't afford lawyers like Mr. Sood or maybe Mr. All these top lawyers we have here. So fact of the matter is that is why now post what the Prime Minister said, post what the CJI said, and post what Justice Sanjay Kishan Kaul has said, I have come across a very interesting aspect. Now that interesting aspect is about 2 weeks back, we appeared in a Prevention of Corruption Act matter where we were representing a lady in a trap case. So of course some big people were involved, so we had a pressure that file bail. Nowadays we have started advising our client that wait for some time, wait for a month, wait for 2 months and then file bail. So but of course the accused are always in hurry, they want bails to be filed. So we were compelled, a few senior advocates, we argued the matter, ultimately bail is denied in the first 2 weeks. So she's an old lady around 67 years of age, Prevention of Corruption Act, serious matter, languishing in jail. Suddenly we get this letter from Tihar Jail, and this is from District Legal Service Authority, Central District. So post what the Prime Minister, Honorable Prime Minister has said and CJI said, initiatives have been taken by DLSA and NALSA at the national level. They on their own, they are going to various jails, they are conducting inquiry, they are picking up cases where bail should be granted. They have a SOP which they have drafted. On the basis of SOP now, the legal aid lawyers will be filing the bail applications. So I got a call that my clerk in fact got a call from a lawyer that I have just been engaged by the Delhi Legal Service Authority and I have to file this bail application. I have checked up the order. You had appeared, so kindly share the details. I said, how can I share it with him? I don't even know him. So then I told the briefing council to check up, with this lady in Tihar, and she made a phone call. There is a now system of having a video conferencing facilities there. She spoke to the lady and the lady said, yes. They came to me. I said, please file it. My lawyers have failed. So now the legal authority has taken up the bail application. According to the SOP which they have drafted, this lady who's 67 years of age, so anybody who's 65 plus and a lady and is covered under 437, so they have their own rules. According to it, they are saying, they are not telling the court grant bail to her. So a situation has come where an authority, legal service authority, now is going to the court and telling the court that look, it's about a month, she is 67, according to our rules, she deserves to be released on bail. I don't know what the fate is going to be, but it's an interesting aspect for us. Because of the fact that there are so many under trial prisoners who are languishing in jail. Problem again, I repeat, blurred area of the criminal justice system. Because this judicial discretion is so wide that it gives the discretion to every judge to decide the bail application according to his understanding of facts and law. May be right, may not be right. But when your applications under 452, like criminal trespass, if they travel to a high court like Delhi, it seems there is something wrong somewhere. Now there was a time when we started off where prosecutors never even used to get up in more than 50% of bail applications. They will never oppose it. So if the prosecutor is not getting up, the judge also gets an indication that there is no opposition. But today, when Mr. Sood and I stand in the court to argue a matter, before we start, the prosecutor starts. So he's so keen to make sure that the bail is dismissed. So idea is, even for prosecutors, we sit here in this room every day and we speak, we have our colleagues on the other side also, they come and discuss with us. I always tell them, I've been a standing counsel, our job is to assist the court. Our job is not to make sure that the bails are dismissed. But anyway, that is, it's again discretion, even of a prosecutor, whether to oppose or not. So I feel this judicial discretion is so wide, it has to be curtailed. So as Vivek rightly said, you can't classify into offences, but I am not classifying. CRPC has classified. Section 41 has classified offences into two categories: less than 7 years and more than 7 years. That is why Arnesh Kumar judgment has come. Arnesh Kumar judgment says if the offence is punishable up to 7 years, the investigating officer is supposed to apply their mind and come to a conclusion whether an accused should be arrested or not. But they don't apply their mind. Investigating officer also feels that when a case is registered, he has to go and arrest. So somebody has to tell him, your job is not to arrest, your job is to find unvarnished truth in the matter. His job is not to file charge sheet in the court. His job is to find the truth and then file a report. That's why we always call report as a final report. We don't say it's a charge sheet or a closure, it's a final report. So therefore I feel that some kind of, it's an overhauling which is required in the system. We as defense also, need to understand this. It is now being highlighted at the highest level that if your under trial percentage is so high as 75, it reflects on our criminal justice system. That is why at the highest level, even the Prime Minister understands that this is a very, very serious issue. So, according to my understanding, I don't think we require a statute because we already have laws, we already have code which has chapters on bail and which has chapters on bail bonds. I have got an opportunity to, read this Bail Act from Australia and also from UK. So when I read both of them, I realized that they're exactly the same as our chapter 33. So the Act and our Code of Criminal Procedure is exactly the same. There is no difference at all. The only difference would be that there will be a statute which is passed by the government, and we have a CRPC, we have a Code of Criminal Procedure. Even Code of Criminal Procedure has to be followed by the investigating agency. It's not that when the statute comes, it will become more powerful. So we have judgments, we have Criminal Procedure Code, we have the assistance of various reports on arrest as well as on bail. That is more than enough. But what is really required is the awareness. What is really required is a liberal approach. I request my friends here to please go and attend the Court of Justice Sanjay Kishan Paul nowadays, because he is one person who has given this judgment. So I appeared, I think 2 days back, and it was a pleasant sight to see that his approach was, towards grant of bail. So the approach has to change, and of course now, we have statutes where there are twin conditions. Now twin conditions are imposed. We have, I think, 5 or 6 statutes where there are twin conditions. We have in PMLA, we have in UAPA, we have in Makoka, and we have, I think Mr. Chadda is nodding because he understands how these twin conditions are difficult in the court. So, and then we have SFIO, Companies Act, where we have these twin conditions. So these are twin conditions which have to be satisfied. So I think 2 or 3 days back I was arguing a bail where of course this new judgment was being analyzed. So a very interesting point came which I would like to share it with you all. It's an excellent judgment, the judgment on money laundering. What was tested in the Supreme Court were the constitutional validity of the provisions of the Act. And the Honorable Supreme Court has come to a conclusion, yes, Section 3, 5, 8, 17, 18 and 45 now all are valid. So it's the Act which has got the validity. but the judgment on bail is until's judgment. That is not a judgment on bail. That's a judgment on constitutional validity. By virtue of it, of course, 45 now has been revised because it was amended. But that judgment of the Honorable Supreme Court does not create any impediment on bail. Because we have to see the judgment on bail, not the judgment on the constitutional validity of PMLA. So in this case, one thing which is very clear, which I think all of you should also now understand, that the exception of 45 is only in one situation where the police does not arrest the accused during the course of investigation. If the police arrest, then 45 will apply, twin conditions will apply. If anticipatory bail is filed during investigation, 45 will apply. But if police does not arrest, file charge sheet or the prosecution complaint without arrest, then of course 45 will not apply, which has now been recently upheld even by a court in Rouse Avenue, we argue. So, these are all finer points from the statutes and from CRPC. My father, always says that CRPC is like Gita. You open, you read, every time you read there is a new interpretation. You collect a set of facts, throw on the Code of Criminal Procedure, it will react differently. A new color will come. So I think that's the beauty of this profession, both for the bar as well as the bench, that every time when we deal with a new case, it comes up with a new interpretation. So law on bail, jurisprudence on bail is developing, which is very, of course, is coming up with these judgments. But I agree with my friend that it's not easy. Bail for a defense, it is very, very tough. You have to satisfy the judges because we fall into, I will not use the word trap, but that figure, that expression of judicial discretion. So judicial discretion has to be exercised primarily in favor of the accused at the time of bail. I personally feel, of course, unless and until there are compelling circumstances, if there is a case of custodial interrogation, yes. If it's a case where the accused, if he is released on bail, he'll commit the crime again, or he is dangerous to the society, gravity of the offence, all those grounds are there. On that, of course, the bail should be denied. And classification of economic offences as a separate category is also dealt with by this judgment.
Yes.
Justice, Sanjay Kishan Kaul has said, you can't classify the offences. That's what Mr. Sood also said. Don't classify. Severity of the gravity of the offence depends on the severity of the punishment. If it is 7 years, then Ranesh Kumar, applies. The discretion should be in favor of the accused. If it is more than 7, then of course you have to see the parameters. So I agree with my friend that we don't need a statute. We have enough laws. Our CRPC is very, very comprehensive, and it deals with almost all the provision. I have seen the Act. This Act talks about this. UK Act actually does not apply to convicts. But when we deal with bail to convicts, we have 389 of Criminal Procedure Code. So they have various chapters on bail and the other chapter, but I don't think we require, our code is very, very comprehensive. It deals with almost all the situation. If code doesn't deal with it, then Supreme Court judgments deal with it. And Supreme Court judgments are binding on everyone. Article 141 says that every court has to follow. And that's what I think even in Antil's case and many other cases, whenever they lay down the law, they direct that every court should follow this. So we expect that courts will follow. We expect that the jurisprudence will grow with the passage of time. Vivek also said that times change, the laws change, the outlook of people change. We remember cases where bail were not being granted 10 years back, now they are granted. So it's a development, it's a constant development. So I endorse my friend's view. We don't need statute. We have enough laws to deal with the aspect of bail. Thank you.
Thank you, sir. Our speakers have shared very valuable information with us and have made us all aware regarding the bail laws and the current scenario and the conduct of the courts regarding bails. Now, we will have a very short question-answer session. If anyone would like to ask anything from our speakers, they may proceed. Yes, sir.
Sir,
Of course, like you have a very wide experience in arguing the bail issues. We are talking only about that at the moment. What is being seen that the judicial discretion has become very limited. The moment we start our case from the trial court, in Delhi, we talk about Delhi, it is impossible for any inmate or accused at the time of the trial to seek bail in the heinous offences. Digital Sood, 376, 377, or we go little money laundering. And what happens, they follow a standard practice. They simply say, "Ji, हमने तो इस case में यही करा है," please go to High Court. Even the High Court judge says that I have been passing this order on regular basis, I am not giving bail. So ultimately then, only option for that inmate is to go to Supreme Court. And how many can go? That's the point, right? So in this situation, should we call it's a lack of judicial enlightenment in the judicial system? Because they are not applying the judicial discretion in view of despite of the repeated judgments by the Honorable Supreme Court and the way the statute has been framed?
Well, I agree with you that this is a problem which we all face nowadays, and most of the bails in heinous offences are being denied and rejected at the lower level, at least I can say, the lower courts. Well, I can only tell you from the perspective of lawyers, what is our duty? Of course, judges have to be trained. There are judicial academies. You find a lot of our High Court judges going to the academy and having a discussion. They must be having discussion on bails also. Sometimes we are also called in the academy to address. But it's a fact that judicial discretion is a very individualistic approach. And discretion, we have judges, I'm not naming them, but we have judges who are very, very broad-minded and very liberal in grant of bail, even in PMLA cases. So, and you'll be surprised when the briefing counsel comes to us or a client comes to us and we discuss bail, the first question we ask them is, who's the judge? So, which bench? In the High Court, we have not 10 judges, 8 single, no, 6. Subjective to hai, so 6 single judges, and we have 2 DBs, so we certainly have to ask. And since we appear in these courts every day, we know how the judges are going to react. I'm sure our assessment and our prediction is close to 100%. So if we say that we will get bail tomorrow, we will get bail. We know how the honorable judge is going to react. So as a member of the bar, as a lawyer, we have to contribute to the development of the law. We have to keep on sharing those judgments, showing those judgments to the court, the best of our ability, telling them this is what the Supreme Court has done. So if Supreme Court has given until judgment, it has to be read across the board. It has to be, discussed across the board. At least every district in the country, every state in the country should have a seminar. Now we have discussed, we are discussing, although we deal with this day in and day out. There are some states who don't have an access to these kind of judgments. It's not, you please come out of Delhi, you will realize in UP far-flung areas, they don't have access to SCC, they don't have access to Manupatra, they don't even know until. If Mr. Sood will go today as a senior counsel, maybe just beyond Noida, just go beyond Noida, go to Hapur, go to Bulandshahr, they don't know what until is. You have to tell them, So awareness, as you rightly says, is very, very important. And discussion on law, seminars, the judicial academy, that's very, very important. Judge has to be trained periodically and regularly. They should have some sessions, every 3 months, 4 months, where they should go and spend time and read. Because they are the one who are making the law. It's only on their judgment that we will be, seeking bail in the court. If you go to lower court, they don't develop the law. वो कहते हैं जी judgment लेके आए हो, ऐसा तो दिखा दो. वो precedent है तो दिखा दो, तो मैं follow करूँ. It's only in the higher courts where there is an interpretation of the provision. So I agree with you, there is a problem, but we fight every day, we show the judgment, we file compilation. So our photocopier works, 24/7. Please go and see my office. We make compilations every day. We cite, we flag, we show the paragraphs. As a counsel, I think that is the best you can do.
I'll just add a few points to what my learned colleague has said. There is a colonial mindset in the lower judiciary, which I've seen it. I know what you mean to say. There's a bail is a no-no in heinous offences. You don't even think about it. There's a colonial mindset where the judge feels there's no accountability. At the most, you can challenge his order, go to the High Court, as you say. So there has to be an accountability mechanism which the High Courts have to enforce. In fact, Arnesh Kumar goes on to say, take action against the magistrates also. The ACRs, etc., take them into, haul them up. Because the magistrate is the first forum where the accused arrested is produced. The justice which a magistrate can do, none else can do in the system. And secondly, there is a fear psychosis also. And there is an unwritten bail code as well. Unwritten code of bail is कि तुम ही ये सारी bails कर दोगे तो फिर हम क्या करेंगे in the High Court. I mean that's these are, you know, we all feel it. There's a look and feel to it. But you just cruise along, you know, do your duty, and as my colleague said, present the judgment, you exhort the judge, be aggressive, keep telling them again and again, and you know, the system will evolve, I'm sure. There's nothing called a system of perfect justice. We are all moving towards, you know, the best justice that is available.
Thank you, sir.
I would like to, just before that question, I would like to welcome Shri Tiwari ji, who is General Secretary of Adhivakta Parishad, Delhi State, who is amongst us. Sir, kindly have a seat here. Welcome you, sir. Now I would like to ask any further questions. Yes, sir. Sir, kindly address your question to the
Sir, my question is to Vikas, sir. Sir, as you mentioned, there are few judgments on anticipatory bail like Sipia and then Maitre and recently Sushila Agarwal. But for a young lawyer like me, they are not case laws but case loads. They do not shed any light on the legal aspects of anticipatory bail, but just lay down the guidelines, sir. So how do we approach, sir, any anticipatory bail, sir?
I think those are, at least Vivek CBI is a landmark judgment. If you read in totality, it talks about jurisprudence, it talks about legality, it talks about how 438 has to be interpreted. And Sushila, of course, is the latest judgment, but it is a culmination of all the old laws. And a new, it's the old wine in new bottle, as they say. So, but Gurbakh Singh CBI is a good reading, and it will give you the constitutional aspect of anticipatory bail, and of course the quality of judgments of that era, of Justice Krishna Iyer and Justice Chandrachud. It's a great reading for any lawyer who is interested in constitution. And my dear friend, you will learn more if you argue more cases, more anticipatory bails, and you will face more orders. Some good ones, some bad ones. You will be able to, those orders will teach you what anticipatory bail is all about.
Any more questions from the guests? Thank you. आप सभी को अभी अधिवक्ता परिषद की तरफ से एक तिरंगे का वितरण हुआ है. मेरी आप सभी से अनुरोध है कि आप सभी तिरंगे को सम्मानपूर्वक अपने घर लेके जाएं और उसे 15 अगस्त के उपलक्ष्य में और आज़ादी के अमृत महोत्सव के उपलक्ष्य में अपने अपने घर पर फहराएं. अब मैं अनुरोध करूंगी श्री अशोक जी से, हमारी अधिवक्ता परिषद दिल्ली हाईकोर्ट यूनिट इकाई के प्रेसिडेंट से, कि वो आएं और वोट ऑफ थैंक्स दें.
My dear friends, Pahwa ji and my friend Vivek ji, they have accepted our request to come and enlighten us on the bail law. As most of the people knows that the bail is matter of rule and not exception. It has to be bail, not jail. So with this, I hope that you must have been enlightened on the bail laws, but the Honorable Supreme Court has stated that bail law in what manner but manner they have not shown. Whether it should be stringent or it should be liberal, that is not there. Now it is the ball is in the government's court to bring the bill or not to bring the bill. So that is the issue. It will go on, and people will come and discuss, and it will go on like this. So thank you very much, Babaji.
Thank you, sir.
Thank you very much, Vivek ji, again, and thank you all the person, those who have attended this program, and I hope they must have learned lot of things here on the bail law. Thank you very much once again. So there is a arrangement for the tea outside. Please wait for the tea and have. Now, one request. We have distributed this flag as it has been stated. It has to be respected. This is the assurance from you to us that flag we are distributing with the help of Poddarji. We have
Thank you.
made 1,000 flags and will be distributing to most of the lawyers
Very
in
good.
the High Court of Delhi.
1,000.
Very nice, very nice.
So we are doing that to celebrate our Amrit Mahotsav, 75 years of independence. So this kind of gesture we have been taking up. So kindly join us in more number to come in the limelight and help the others, lawyers, that they are also doing work and you are also doing their work. While working, we are serving, not otherwise. Thank you well. Thank you.
Now a request